Good faith is a concept of law that permeates many areas of law, particularly contracts, financial transactions, criminal law, methods of dispute resolution, particularly direct negotiation between the parties, and mediation. So, any lawyer who is practicing law or any judge who is resolving cases is very sensitive to the concept of good faith. Now, these two words, good faith, mean a lot of things. Good faith means sincerity. For example, when you're negotiating or when you're mediating a dispute, you must be transparent. You must be sincere in the objective of resolving a dispute. Good faith can also be understood as honesty in fact, that you're not trying to play technical games. You're honestly conducting a negotiation, or you're honestly putting all the facts that are relevant to a transaction on the table. Now, the opposite of good faith, of course, is bad faith. And bad faith means dishonesty, it means opaqueness, it means that you're not sincere. There's an element of intentional undermining of a process, whether it is prosecution, whether it is contract making, or whether it is negotiation. So good faith is the central nerve system of law, and it is absolutely critical that lawyers, law professors, as well as judges understand the significance of good faith. Now, good faith should be distinguished from incompetence or mistakes or lack of knowledge. Just because you don't know anything, or just because you're incompetent or you are making a mistake, that does not mean that you're engaging in bad faith or you are not conducting yourself in good faith. Good faith is honesty of what you know. It is sincerity of your purpose. It is being transparent. And particularly in contracts and financial transactions, where parties rely on each other's representations, where parties make a deal on the basis of known facts, it is important that parties conduct themselves in good faith. They are honest. Now, even though good faith is honesty in fact, increasingly, good faith is not considered to be a purely subjective state of mind. There is some objectivity to good faith. So in that sense, incompetence and lack of knowledge could contribute to bad faith or could undermine good faith. For example, if you're a banker, you must know what the banking traditions are. If you're a lender, you must know what the lending laws are. So if you deliberately undermine the knowledge of law, or you deliberately do not acquire the knowledge of law relevant in the field of your business, whether it is banking or lending or even prosecution, which is totally different thing, criminal law, your lack of knowledge or your incompetence, even your negligence, could be a factor in determining whether you were acting in good faith. So good faith is both subjective and objective. It is subjective because you are required to be honest. You are required to be sincere. Your state of mind, your inner self is supposed to be transparent. And it is objective in the sense that you understand the knowledge of your business, you understand the customs, you understand usages, you understand the law of the area in which you are doing your business. So in the case of criminal law, for example, a prosecutor would be engaging in bad faith, perhaps, and definitely undermining good faith if on the basis of the evidence in the file, a reasonable prosecutor would not bring the case for prosecution. So even though a prosecutor honestly believes that the evidence requires prosecution of a case, but no reasonable prosecutor who understands the law, who understands the prosecutorial conduct and the ethics of prosecution would bring such a case, then we could say that the pure subjectivity of the prosecutor is not enough to constitute good faith, and that a responsible prosecutor would also be a reasonable prosecutor, and thus the subjectivity and objectivity come together to constitute good faith. So similar synthesis of subjectivity, honesty in fact, and objectivity, which are the traditions of a business, they must come together in order to define what is good faith dealing.